Another element of your talk involved the occupational licensing issue, which, at least in terms of its public rationale, is the purpose of licensing is to protect the public from unscrupulous snake oil salesmen. But either because of political operation or the looseness of the laws, it's really become a rent-seeking vehicle or a protectionist vehicle. How does that play out?
Well, what happened is that because of the rational basis test that the court created in the Nebbia case in 1934, and that it continues to apply to this day in cases involving occupational licensing, it's virtually never that a court will strike down an occupational licensing law as unconstitutional. So legislatures are pretty much free to do whatever they want. And when the legislature is free to do whatever it wants, that means that political coalitions are going to be formed in order to pass laws that benefit those political coalitions. That's the basic insight of public choice economics. And the Founding Fathers were very familiar with this idea. We talk about it as though it's a recent development in economic science, but Federalist 10 and Federalist 51 talk about the problem of factions, and that's exactly the same issue. And the Constitution was written to prevent this problem. And there are all sorts of clauses that prevent it, primarily the due process of law clause in the Fifth Amendment and again in the 14th Amendment. These clauses are supposed to prohibit the government from passing laws that benefit particular interest groups at the expense of other people without any actual connection to the public welfare. Now, when an occupational licensing law actually protects the general public, as in medical licensing in the famous case of Dent versus West Virginia, the Supreme Court upheld that law, even though that was a period of time before the rational basis test, when economic liberty was taken seriously. But what we've got now is occupational licensing laws that have no connection to public health and safety, that really just exist to shut down fair competition. The primary example of this is a case in the state of Oklahoma where it's illegal to sell coffins without being a licensed funeral director. Now, this requires 2 years of training and tens of thousands of dollars to get this license. This law doesn't protect the general public. It exists to protect those who have funeral licenses from fair competition by entrepreneurs who have a better idea and want to compete at a lower price. And the 10th Circuit Court of Appeals said that's perfectly okay. Even though the law has no connection to the public health and safety, it's okay for the legislature to hand out these kinds of economic favors.
All right, so we have a philosophical shift early in the 20th century that led to a shift in the legal landscape, and the shift in the legal landscape then enabled a whole series of political entrepreneurs, including rent seekers of this sort. All right, so we're now in a situation then on your analysis where the legislature in the United States is free to do what it wants pretty much on economic issues, and the court is turning a blind eye, having gutted those economic limitations, right, placed on legislative powers. Or if we then go from philosophical change to legal change to our current business climate, which has any number of unhealthy elements in it, in your judgment, how do we turn things around? Again, very difficult, but what I did like in what you said is, particularly as a philosophy professor, that there's a big role for philosophy here.
Absolutely, and really that is where it has to change, is philosophical change. It's a very long tail, you might say. When you look at the history of economic freedom as a matter of law in America, you see that it took 50 years from the 1880s to 1934 before the progressive attack on individual economic freedom succeeded in the formation of the Nebbia case. Well, it's going to take at least equally as long to undo that if that's what the American people decide to do. And to do that requires first changing our attitude toward the role of government in our lives, toward the meaning of liberty under the Constitution. What the progressives did, the progressives were very smart people. I mean, we're talking about people like Oliver Wendell Holmes, who was unquestionably a genius. But what they did was they shifted the ground of political philosophy in this country by rejecting the principles of natural rights, by rejecting the foundation of American constitutionalism. If you read Justice Holmes's dissent in the Lochner case, for example, there's a line in there where he says, "A constitution is formed for people of fundamentally differing views." Now, if you think about that, that is just absurd. That is totally insane. That is throwing down a gauntlet to 2,500 years of Western political philosophy, which holds that you can only have a constitution among people of fundamentally shared views, right? The whole problem we're having in the Middle East is trying to form a constitution among people of fundamentally differing views. You can't even have a marriage with somebody of fundamentally differing views. How can you have a constitution with them? Well, the American founders believed that you do have to share fundamental views. And where did they articulate those views? In the Declaration of Independence. They said these are the fundamentally shared views on which we are going to create the Constitution of the United States later, right? They say we believe government exists to secure individual rights. Then a decade later they come along with the Constitution to say to secure individual rights we're creating a Constitution. They shared a consensus on philosophical principles. Holmes comes along in 1905 and says constitutions exist for fundamentally differing people. And what they do then, in his view, is they channel the power of the majority and allow them to enforce their will on the minority. They allow instead of going to war with one another, we're going to use the vote to steal each other's property and manipulate how society operates and dictate how other people can live their lives in a more peaceful way. That's Holmes's attitude toward government. And really, Holmes's dissent in the Lochner case is the manifesto of progressive era legal theory. And that is basically how we live today, with some dramatic exceptions. I would say, actually, that one of the saving graces of the 20th century is the civil rights movement of the 1950s and 60s. If you look at what the civil rights movement was about, what Martin Luther King was accomplishing at that time, he was undoing a lot of what the progressives had done philosophically. King was always insistent on the importance of the principles in the Declaration of Independence. He reiterated those principles time and time again. He said, we have to bring ourselves back to the wells that were dug deep by the American founders in the Declaration of Independence. Right? He restored and he forced America to recognize the moral questions involved in the power of the majority. And that was the question the progressives had tried to wipe away. They had tried to say that whatever the majority says is okay. And what King and his followers helped to do was show us that no, that's not the case. The democratic majorities can be wrong. There are principles that are more important than majority will. So I think that what we saw in the 1960s was in some areas of law, we saw a backing away from some of the worst elements of progressivism. And that's why I characterize the defense of economic liberty as a civil rights movement. It's part of restoring America's recognition of the importance of wealth creation and the moral right of a person who creates wealth to that wealth.
All right, nicely put.
Thank you.
All right, thanks for being with us today.
Thank you.